the reality is that the employee has an option. He can decide to challenge the minister's decision. But I think the percentage of employees who challenge the minister's decision very small. Maybe you're talking 2-3% of employees whose case is not referred, they challenge. You know why? To challenge the dismissal, they have to do it by way of what is known as judicial review, and judicial review has to be done only at the High Court. Now, it is called the High Court for one reason, because the cost in that court is high, right? So therefore, most employees who the minister says don't refer, they are going to think, do I now want to take out money and pay a lawyer and challenge? Considering the minister said don't refer, do I want to risk the money? Yeah. But of course, remember I told you the Industrial Relations Act applies to every employee. So someone who's a high earner, an MD who has been dismissed, whose salary is say 50,000 ringgit, paying 15,000 ringgit as cost to go to the High Court may not be a lot for him. So there are some cases of employees rather challenging the decision of the minister. Yeah? But normally, if not referred, matter normally ends there unless it's challenged. But if the matter is referred, what happens? That's when you have your full drama that you see in all your law movies. The lawyers will be there, the judge will be there, witnesses will be called, and you will have the full trial. Right? In practice today, the court also tries to settle before it goes to full trial. But if there's no settlement to be had, then you'll have the full trial, and that is where employers then will have to convince the court, persuade the court that the dismissal was fair. You must understand that if an employee sues the employer and it goes to the industrial court, it is the employer who has to prove that the dismissal was fair. Yeah? Employee does not have any burden of proof. It is with the employer. And I will share with you that there are some serious challenges for the company once it goes to court because of the practical nature of things. For example, the timing. Between the dismissal to the trial, I think today we are talking about a year and a half, maybe even longer. So what happens is, because the employer has to prove, sometimes during that period, crucial witnesses may have resigned and left. Documents may have gone missing. So you find yourself in court without having the ability to prove the dismissal. And therefore the employer's case is compromised. Now, what happens if the employee, if it goes to court and the employee wins their case? What will the industrial court order? This is where, when Roy talked about the amount of compensation ordered, it can be very, very significant, because if you look at this, Section 20, subsection 4 states, the industrial court can award up to a maximum of 24 months back wages, provided that the time between the dismissal and the decision is at least 24 months or more. So for example, if someone was dismissed 1st of January 2012 and the case is completed today, that's more than 24 months, right? So court can potentially order a maximum of 24 months as back wages. Ordinarily, the courts will deduct from the back wages any salary that the employee earned after he was dismissed. So let's say he was dismissed 1st January 2012, maybe for the first 6 months he didn't get a job, but on the 7th month he got a job. The amount that he earned thereafter normally will be reduced by the court. I say normally, the court has the power to decide not to make a deduction if they so desire. And it has happened in some cases where the courts have felt that the employer has acted particularly unconscionably. So to sort of punish the employer, they say, I'm not going to make a deduction. It can happen, right? But I'm just giving you the maximum is 24 months back wages, plus the employee can get his job back. Remember, under Section 20, the employee is asking for reinstatement. So he gets 24 months back wages and he gets his job back. No loss of service, no loss of seniority. So imagine if you were the boss who sacked this person, and 2.5 years later he wins his case, you pay him 24 months and he comes back and reports to you. You're not going to be a happy camper, yeah? But I must say that I think today the courts, the tendency to order reinstatement is getting very minimal, because most of the time the relationship is broken, the employee has moved on, working elsewhere. So normally the industrial court stand, instead of reinstatement, they order 1 month salary for each year's service as compensation in lieu of reinstatement. So if the employee worked with the company for 10 years up to the point of dismissal, he gets 10 months as compensation plus maximum of 24 months of gratuities. So you can see now that the consequences of dismissing an employee without following the proper process and the proper the laws are very significant. You could end up paying a lot of money, and of course this excludes legal cost. Yeah, right. So cost will be borne by each party. So there is legal cost and there's also time cost. You know, your time in preparing you. If it goes to court, your lawyer will need to prepare the case together with you. So you'll have to spend a lot of time with the lawyers. All the witnesses will have to spend time. The lawyers preparing witness statements, and then going to court. It's a very lengthy, and I must say it's quite for employers, because going to court is not fun. You must understand, when you are in court, you see, this is where the playing field becomes a bit more level. When you dismiss the employee, did he have a lawyer? No. But when he goes to court, he has a lawyer. So at that, in court, the lawyer for the employee will question you guys, the employers, the witnesses. And their job is to make you look like you are unreasonable, make you look like you did not know what you're doing. Therefore, to try and convince the court that the dismissal is unfair. Yeah? So this is the full process. As you can see, it is very, the costs are significant. What I want to share with you is, I told you earlier, I will do a little bit of share with you the practical aspects. Now, I'm going to put this down on the board here, and I put it down as advantages for employees. Yeah, let me just get some space for this. I call it advantages for employees that our processes provide. And the first advantage, I actually touched upon this earlier, because the wordings in the Industrial Relations Act says where a workman considers, right? So basically the first advantage is any dismissal can be challenged. Even though the dismissal was perfectly fine, it does not stop an employee from filing a complaint, because the wording is where a workman considers. And I find that is the reason why you have so many cases. Because what are the chances of an employee who gets a dismissal letter going, looks at it and says, fair, I deserve this? Very small, right? Most employees would consider it unfair. This is why, when you talk about dismissing an employee, leaving aside the law, the words that I would use for you guys would be, you have to manage perception. You have to manage the employee's perception such that he feels that you have been fair. If you don't do that, you are going to push him towards filing a complaint. Right? So that's the first advantage. Any dismissal can be challenged, even though the dismissal was perfectly fine. Right? The second one, burden of proof. I also shared this with you just now. When you are in court, you have the employer and the employee. The normal rule on burden of proof is this. If I am suing you, I have to prove. Correct? For example, let's say I took a loan from Hong Kong Bank, personal loan for 10,000 ringgit. I'm supposed to repay 1,000 ringgit a month for 12 months. Money is given to me. I don't make the repayment first month, second month, third month. Hong Kong Bank starts sending letters of demand. I ignore the letter of demand. So now Hong Kong Bank has got no choice. They've got to sue me. So now, for the court to decide, the court will want to see a few things. Number one, was there an agreement between Daman and Hong Kong Bank? Number two, was the $10,000 paid to Daman? And number three, did I fail to make the repayments? If the court can see these three things, they're probably going to say, Daman, pay back Hong Kong Bank. Correct? Who do you think has to prove these three things? Hong Kong Bank or myself? Surely Hong Kong Bank. It's logical, right? Because the normal rule is, he who sues has to prove. And it makes full sense. Because if it was the other way around, you know what I'll do? I'll sue the whole world. I'll sue, say, you owe me 100,000, you prove you don't. You owe me 50,000, you prove you don't. Doesn't make sense, right? If I sue, I must prove. If we take that philosophy and use it in under section 20, right? So who is suing who? Is it the employer suing employee or employee suing employer? Employee suing employer, right? So the burden should be on the employee, right? But the industrial court reverses the burden. The burden is on the employer to prove that the dismissal was fair. This is very challenging because of the third advantage. The delay in the process. I put that down as an advantage for employees.